Welcome to Module 4, Week 7. During this week, we will be covering Chapter 8, Protecting Patrons' Property. As I mentioned to you, certain terms are going to be widely used throughout the semester. That is why we will focus again on terms. Obviously, we have liability towards hotel guests as it pertains to hotel theft. Key cards and keys is another item that we control heavily. There are strict procedures that pertain to who can be issued a copy of the key, who can we share the information with as it pertains to keys, names, room numbers, things of that nature. It is very unlikely that a guest carries an insurance when they travel, and that is why theft, when it pertains to guest items, becomes a high liability hot topic. Our jobs as hospitality managers is obviously to prevent those lawsuits from happening. It is important to know the strict liability term. It is also called absolute liability, and that is a doctrine that imposes that all the risks on a ultra hazardous activity upon those who engage in it. Infra hospitium, that's another term that is used, and it means within the inn. It comes from Latin, means within the inn, and under that doctrine it states that under common law, the liability insurance needs to be carried by the property in order to protect guests' property. Another thing that we need to take into consideration, and the strict liability law has kind of exceptions to the rule. Whenever the loss is attributed to an act of God or something that is not within the control of the proprietor or the hotelier, meaning if there is a flood, if there is a natural disaster like tsunami, tornado, hurricane, something that comes from the act of God or the act of nature, obviously we're not in the control to foresee or prevent things from happening. Obviously, that will exempt the property from absolute liability rule. If the loss was caused by a public enemy, also that becomes part of the exception. And under public enemy, we will include, losses that could incur during wartime or losses that could incur due to terrorist attacks or active shooter, somebody that is considered a public enemy. And the last one is whenever the negligence has occurred because of the guest's wrongdoing. So imagine you're going at a busy hotel and you decide to leave your luggage with millions of dollars unattended. Likelihood that that luggage will be left at the same spot unsupervised is very unlikely. Obviously, that is going to be considered the negligence of the guest per se. Prima facie liability, that's a rule that states that hotel keepers or innkeepers are liable for property only if the loss occurs through their negligence, meaning the hotel could have foreseen and prevented the loss from happening. If the loss results from other causes, then the innkeeper is not going to be liable again. It could be an issue due to the negligence of the guest per se. Limiting liability statutes, those are laws that restrict an innkeeper's liability for property loss in exchange for strict statutory compliance by the innkeeper, or those are also called limiting statutes. Most limiting statutes require that the posted notice be conspicuous, meaning it needs to be out in the open. So to give you a good example of what a conspicuous note will be in a hotel room, if you have ever been in a hotel or if you're planning to visit a hotel anytime soon, please close the door. And on the back of the door where the peephole is, there will be some kind of a sign. On that sign is going to tell you the innkeeper statutes of the state in which that hotel is located. And within those statutes, it's going to say if you keep your items in the safe, we are not liable for the full price of the lost item, things of that nature. So take a look at it and see what you see. But that is what we mean by conspicuous, obviously, posting. Equitable estoppel, that's a legal principle that precludes that a person from claiming a right or benefit that might otherwise have existed because the person made a false representation to a person on it to his or her detriment. So in kind of our own words, if the hotel makes false claims towards the guest in order to make them make certain decision, if I know that, for example, my property is in a high-risk area where there is a lot of burglaries, a lot of theft, a lot of criminal activity, and I tell a guest, oh, by the way, don't you worry, this is the safest neighborhood, right? So I am obviously stating a lie. Should something happen with that guest when they're visiting my property, I will be excluded from the limited liability. Why? Because I did lie. Okay? So we need to be very, very kind of conscious on what we say and what we do as it pertains to guests. Another term that I would like to mention is bailment. So bailment is the act of transferring goods or personal property from one person to another, with the understanding that it is just for a limited amount of time, and then the person that received it will give it back. The person that is the owner of the goods or the personal property is called bailer, and the person that is receiving the property is called bailee. We have a couple of things that need to exist in order for a bailment relationship to exist. First, the existence of the good or the personal property. Delivery of possession, I need to give my personal property to somebody. Then the somebody needs to accept that, which is acceptance of possession. And then the bailment agreement, which is the agreement that you will give it back to me. Maybe it's going to be just for you to hold on without payment, or for you to hold with a payment. Here I want to give you a very interesting bailment example. So you know how you go and valet park your car? You ultimately give your keys, right? That means that you relinquish possession of your item, and the bailment agreement is you're paying, let's say, $25 for valet parking, and in return you're going to get your car parked and returned back to you in the same condition. That's why those tickets, valet tickets, have this, drawn little car, and if there is any hits or dents on your car, they get marked. This way, when you receive the item, you accept that all is good and you received it in a proper condition. Now, with valet services or with valet bailment agreement, what is very, very important is who has the key. So courts have found that even if you valet your car, but you require for the key to be returned back to you, that car has not become part of the bailment agreement. So there is no bailment agreement between you and valet parking. Within the textbook, you have quite a few examples that I will advise you and strongly urge you to read. But you have to understand, a lot of things get taken into consideration prior to a case being decided.